A very good morning to our honorable guest speakers and fellow participants. Welcome to our legal webinar episode 1 today. Our topic is the legal perspective of adoption in Malaysia. My name is Eng Siwei and I'll be the moderator as for today. Now, please allow me to introduce our guest speakers, which are Mr. Goh Yong Han, Ms. NURUL SYAMIMI binti Nur Aslan, Ms. Tan Sin Mei, Ms. Beverley AIDELL Andrew, and Ms. Grace Michelle Philip. Before we proceed to our sharing session, let me introduce the concept of adoption with you. Adoption is the legal way whereby a person takes another's child to become the legal parents of the child and be taken care of as their own child. Legally, adoption denotes a process whereby the birth parents of a child fully transfers legal parentage and vested it to the adoptive parents. Without any further ado, we will now start our sharing session. The first question is directed to Mr. Goh Yong Han. Can you brief us a little about the governing laws of adoption and its legal effects in Malaysia?
Okay, thank you for the question, Ms. Hui. Alright, in Malaysia, there are two separate statutes that govern the adoption of children, namely Adoption Act 1952 and Registration of Adoption Act 1952. So, what is the difference between these two statutes? Firstly, we can compare it by examining their applicability. The Adoption Act is only applicable to non-Muslim, while on the other hand, the Registration of Adoption Act is applicable to both Muslims and non-Muslims. And this act mainly applies to the registration of the de facto adoption. Besides, it is noteworthy that both statutes are only applicable in West Malaysia. Apart from that, we can compare the legal effect of both statutes. As provided under Section 9 of the Adoption Act, once the adoption order was made, the adopted child was legally considered as the child born to the adoptive parents in lawful wedlock. Whereas under the Registration of Adoption Act, the Act is noticeably silent on the legal effect of the registration and does not confer the adopted child status of rights of a natural son and daughter. Next, regarding the application for an adoption order, a child adopted under the Adoption Act requires a formal application to court and concludes with a court order allowing the adoption. In this regard, the High Court and Session Courts have jurisdiction under Section 10 Subsection 1 of the Act to make adoption orders. If the application allowed, the Registrar of the General of the National Registration Department shall issue a certificate of birth in respect of the child under Section 25A Subsection 3. Compared to Registration of Adoption Act, the Section 6 Subsection 1 of the Act provides that the child must be in the custody of the adoptive parents under any de facto adoption and has for a period of not less than 2 years and express consent from the birth parent is required. In this matter, Section 9 confers power to the Registrar of Adoption to summon and examine witnesses and the administration of oaths and affirmations. If the application allowed, an entry will be made in the National Registration Department and a certificate of adoption will be issued.
Thank you, Mr. Goh. Ms. Syamimi, can you enlighten us on who can apply to adopt a child?
Yes, sure. So, as provided in Section 4 of Adoption Act, the applicant must attain the age of 25 years old and the applicant must be older than the child by 21 years old. For the applicant who attained the age of 21, the applicant must be the child's relative. The father or the mother also can be the applicant if the child is born out of wedlock. However, the mother must consent if the father wants to apply for the adoption. In any case, if the child has not been registered earlier, the parents may also apply for the adoption, but it is the rare case ever happen. Be noted that male sole applicant is not allowed to apply for adoption on female child. Also, the applicant has been continuously care and treat the child. The applicant must be the resident of Malaysia. Meanwhile, in the Registration of Adoption Act provided in Section 10, the applicant must be a resident of Malaysia as one of the conditions to be allowed to adopt a child in Malaysia. It is also to be noted that the applicant has attained 25 years old and must be at least 18 years old older than the child. As the relative of the child, the applicant is allowed to apply to adopt the child at the age of 21 years old, and in this case, the applicant also may be the parents of the child too, just as in the Adoption Act. Thank you.
Thank you, Ms. SYAMIMI. My next question is for Ms. Tan Sin Mei. May I know what are the qualifications for a child to be adopted?
Thank you for your question, Ms. Ng. So, under the Adoption Act 1952, the child to be adopted must be under the age of 21 and includes a female under the age who has been divorced pursuant to Section 2 of the Act. Besides, it also requires that the child must be resident in Malaysia. While under the Registration of Adoption Act 1952, the child to be adopted must be under the age of 18 and has never been married pursuant to Section 6, Subsection 1 of the Act. The Act also requires that the person seeking the de facto adoption must have a physical custody of the child for a certain period of time, and the law requires it to be 2 years continuously. If the requirements of 2 years was not fulfilled, the registration for adoption will be treated as invalid. That's all from me. Thank you.
Thank you, Ms. Tan. Ms. Beverley, as far as I'm concerned, consent is a very important element in an adoption procedure. Can you please explain more about it?
Thank you for the question, Ms. Ng. I indeed agree that it is related to the welfare of the child. We wouldn't want the child to grow in a family that he is or she is not comfortable with, right? As Mr. Goh has explained earlier, the adoption process in Malaysia are governed by Adoption Act 1952, which is applicable for non-Muslim, and the Registration of Adoption Act 1952, which is applicable for both non-Muslim and Muslim. The requirement of consent is necessary in the adoption procedure that both of these statutes provide about consent. Section 5, Subsection 1 of Adoption Act 1952 states that an adoption order shall not be made except with the consent of the parent or guardian of the child or who is liable to contribute to the support of the child. The court may dispense with any consent required by this section if it satisfied that the child has been abandoned or persistently ill-treated the child, the liable and responsible person has refused to contribute to the support of the child, this person whose consent is required is incapable of giving consent, or the law allow any competent authority to give permission or granted a license authorizing the care and possession of the child to be transferred to the applicant. For example, in the case of re-BBM, the natural parents of the infant baby agreed to give her up for adoption to the applicant by signing the letter of consent. However, they changed their minds and sought for the return of the child, alleging that they had not given the consent and that the letter was invalid. After considering the totality of the evidence, which is the serious neglect by the natural parents and the fact that the child was in need of medical attention, the court held that the consent was unreasonably withheld by the natural parents and therefore should be dispensed with. Section 6, Subsection 1b of the Registration of Adoption Act 1952 states that if the parents or one of the parents, or if both the parents are dead, or if neither of the parents is within Peninsular Malaysia, any guardian of the child shall appear before the registrar and express consent to the adoption, provided that if the registrar is satisfied that in all the circumstances of the case, it is just and equitable, and for the welfare of the child, he may dispense with the consent of any parents or custodian of the child, or with the appearance of any parent or custodian who shall have signified his consent by statutory declaration. That is all from me. Thank you.
Thank you, Ms. Beverley. Here comes my last question for Ms. Grace. Can you briefly explain to us the procedure to adopt a child?
Okay, thank you for the question, Ms. Ng. Indeed, procedure is very important in adopting a child. Firstly, let us look at the procedure in accordance with the Adoption Act before we go to the Registration of Adoption Act. In Section 4, Subsection 4 of the Adoption Act stated that the applicant should inform Social Welfare Department 3 months before about the intent to adopt. Further, Section 11 required an application for an adoption order to be presented in the applicant to the court, and any written consent required to be included with the application shall be in prescribed form. Also, the court shall appoint a guardian ad litem to the child to investigate all the circumstances of the child and the applicant in order to safeguard the interests of the child before the court. While the procedure in accordance with the Registration of Adoption Act can be seen in Section 3, which stated that the Registrar General shall have general charge and supervision of all registers of adoption kept under this Act, and all registrars of adoption shall be subject to his direction for the purpose of this Act. So that's all for the procedure. Thank you.
Thank you, Ms. Grace and the panel of speakers. Before the end of our legal webinar, I have a word of advice to all. For those who are intended to adopt a child, you must be well prepared to bear the responsibility of being a parent. Thank you everyone for joining us today. Stay tuned for Legal Webinar Episode 2.